this time, I would like to call this meeting to order. Good evening, everyone. Today is Thursday, October 27th, 2022, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. Commissioner Wright, would you like to lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Ms. Secretary, may we have a roll call, please?
Commissioner Kerpes. Commissioner Maggio.
Here.
Commissioner Martz.
Present.
Commissioner Montemayor. Commissioner Wright.
Present.
Vice Chair Ayers.
Here.
Chair Topshin.
Here. We have a quorum. Thank you. Approval of agenda is the next item. Has everyone had a chance to review tonight's item?
Motion to approve. Second.
We have a motion and a second. Ms. Secretary, may we have a roll call?
Commissioner Kerpes.
Aye.
Commissioner Maggio.
Aye.
Commissioner Martz.
Aye.
Commissioner Montemayor is absent. Commissioner Wright.
Aye.
Vice Chair Ayers.
Aye.
Chair Topshin.
Aye. Motion carries. Thank you. Next is approval of minutes. We have before us the minutes for the meeting on September 22nd, 2022. Has everyone had a chance to review the minutes? We have a motion?
I find the minutes to be correct. I'll make a motion to approve the minutes of our last meeting. I'm sorry, the date is
September
what is it?
22nd.
September 22.
Second.
Okay, so we have a motion and a second. Ms. Secretary, may we have a roll call, please?
Commissioner Kerpes.
Abstains. I was not here.
Commissioner Maggio.
Yes.
Commissioner Martz.
Aye.
Commissioner Wright.
Aye.
Vice Chair Ayers.
Aye.
And Chair Topshin.
Aye. Motion carries. Thank you, everyone. Ms. Secretary, do we have any public comments at this time?
I see that there are 3 people in the waiting room, so I can admit them one by one, just to make sure that
Okay,
they have public comment.
so they joined the meeting by Zoom, I guess, right?
Yes.
All right. So, yeah, we just before we go there, I just want to announce that the Rent Civilization Commission values or comments. However, pursuant to the Brown Act, the Commission cannot act on items not listed on the posted agenda. Members of the public will have 3 minutes to speak. The public comment period is to address the Rent Stabilization Commission on agenda items or items of general interest within the jurisdiction of the Commission. An additional public comment period is available at the end of the meeting. Before you begin, please state your name and the city of residence for the record, and you will have 3 minutes to speak. So we may begin with the first speaker, Ms. Secretary.
Mark, can you hear us? Mark, you can go ahead and unmute yourself.
Hello, can you hear me?
Yes.
Great.
Yes, sir, please state your name for the record, and you will have 3 minutes to begin.
My name is Mark. I'm here to view. I am a coworker to Adam Rosecrans, who will be the one presenting.
Chair, that is the landlord for the appeal.
It's part of the appeal. So then you will have to wait until we have the appeal section. You can't really speak in the public comment now, so there will be a time for you to address the commission when we start the appeal. Okay?
Oh,
You'll be placed back into the waiting room, Mark.
sure.
All right, thank you. Anyone else is here to speak not on the appeal item? It's just a general comment. You may speak, you may have your 3 minutes now.
There's no one else.
No one else. All right. With that, I just want to, for the record, I want to acknowledge that the commission received emails from the constituents, and the emails are a part of the public comment record, and I just want to acknowledge that. What's next? Since we don't have any other, we don't have any public comments at this time, we're gonna move on to the manager's report. Okay, yeah, it's Mr. Hollab. This is your time. Good evening.
Good evening, Chair, Vice Chair, Commissioners. Jonathan Hollab, Rent Stabilization Manager. On the look ahead, we have in the queue the remainder of our appeals for the year. Tonight, you'll be hearing D4652. There is a slight adjustment to the order of the appeals. On the 10th, you'll actually be hearing 2 D4674 and D4687, and then on December 8th, the I-152 case along with D4689, which is actually also related to the same property. So those will be going forward on the same day. Since we last met, I received word that Betzetic has taken 8 new cases in the month of October. So it's not spiking, but it's steady. I'd also like to let the commission and the public know that about a week ago, a judge of the Central District of California, that's the federal court for Los Angeles, issued an order granting a preliminary injunction to the Apartment Association of Los Angeles, which will likely have an impact on the county's tenant protection resolution. The provision related to the tenant's ability to self-certify if they are at 80% or below the area median income may be impacted. It's unclear at this point whether that will go into effect, although because the judge delayed the injunction until December 1st, and made a note in the order that one of the reasons for delaying is that it could give time to the county to correct what the judge saw as the constitutional issues with the language in the ordinance. We just got word of the decision, so we're reviewing it now. I'd point out that the tenant protection resolution for the county was set to expire on December 31st, but it could have an impact for that final month. At this point, I'm not sure what the impact will be exactly, or what the county will do or not do, but as we learn more, we will get that information out to the public through our website and through our usual outreach methods. And I'm available for any questions.
Questions to Commissioner Kurpis and Commissioner Martz and then Kurpis.
That's that ruling, either by email or the filing name.
Certainly. It is, I'll give you the name and I'll share it with the commissioners tomorrow. It's the Apartment Association of Los Angeles County v. County of Los Angeles, and it was heard in the Central District and was issued on the 19th of this month. So I will email that to all of you tomorrow morning.
Thank you
at the
very
latest.
much.
And then my question related to this as well is does the city have the authority? I know it's the county's ordinance that's in question right now. Does the city have the authority to implement a similar protection, maybe with the correct wording that the court was leaning towards in that amount of time by December 1st?
I don't know yet. We just became aware of it today, so we have to review it. Thank you.
Other commissioners, questions? All right. Okay, thank you, Mr. Manager. Commissioners, this is our time. If you have any comments to make, Commissioner Maggio.
Yes, good evening. I wanted to report that I did attend the Transportation Commission as the liaison from Rent. Although I did not make a report, I actually went to be educated. It was an interesting evening that discussed the expansion of outdoor dining and all the particulars that go with it, mainly the safety issues. I believe staff from transportation, I'm going to ask Jonathan this, will be making presentations. I know they haven't come here yet. Have they scheduled that to come here?
Not yet.
They have not. Okay. Well, hopefully they will. It's been a very interesting process, and it's going to help to expand the outdoor dining concept. Thank you.
Thank you. Other commissioners, any comments at this time? Commissioner Corpus.
I'll just say I attended the, or via Zoom, I attended the public meeting on the Fountain Avenue changes, adding bicycle lanes, the feasibility study, and that the city has extended the survey that they're asking the community to fill out regarding the project, and I believe they've extended it to November 13th. I'm looking right now, but I believe it's November 13th when they extended the deadline.
There will be a public meeting, though, in person, right, in regard to that?
I don't know what further public meetings other than to the council that will be taking place.
Okay, thank you.
Thank you. Okay, commissioners, thank you. We're going to move on to the next item of our agenda, which is the appeal section. And tonight we have one appeal before us, and that is a rent decrease application number D-4652, which pertains to the property address 1216-1224 North La Cienega Boulevard. This appeal has to do with the rent reduction due to the loss of services. This appeal is filed by both tenant and landlord, and the record shows that the tenant filed the application first. Ms. Secretary, first I want to confirm if the representative for both tenant and landlord are present for the record.
The tenant is present in person and the landlord is present via Zoom.
Okay, and they're connected, right? They can hear us.
I can connect him.
All right, yeah, let's admit them. Okay, since the landlord or landlord's representative is admitted and I believe they can hear us, I would like to begin with stating the instructions of the appeal tonight and explain the process. First, the commission will hear a staff report presented by our legal counsel, Mr. John Natalizio. And after that, we will have a public comment portion to hear public comments. And then there will be an oral argument following the legal counsel's report. Since both parties appealed, both parties will have, each party will have 5 minutes, and each party will be able to split their time, their 5 minutes between the presentation and the rebuttal portion of the argument, of the presentation. So, before the parties begin to address the commission, that you will have to state your name and the city of residence for the record, and then you need to indicate if you would like to, if you wish to divide your time, and how would you wish to divide the time. And after that, you will proceed with your comments. Since your speaking time is limited, it is very important to keep the following things in mind. Make sure that you keep your comments on topic. The only information you want to share is the information that is about the appeal topic. New evidence cannot be considered by the commission. You may discuss the issues that were raised or the information that was provided at the hearing and or the evidence that was submitted to the examiner. If you go off topic, you will be interrupted by the legal counsel or myself. So with that said, I would like to hear the staff report. Mr. Natalizio, the commission is ready to hear your report.
Good evening, Chair, Vice Chair, Commissioners. This is John Adalizio. I'm the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. As the chair mentioned, this appeal was filed by landlord, which is Empire View Homes LLC, and the tenant, Sharice Michelson, in response to the hearing examiner's decision, which is granting in part and denying in part a rent reduction application submitted by Ms. Michelson regarding 31 common area and unit-specific issues, as well as seeking a determination of her maximum allowable rent and any rent overcharges. Both tenant and landlord appealed, claiming that the decision is clearly in error, is not reasonably supported by the findings made or evidence in the record, constitutes an abuse of discretion, and is contrary to the law. Due to the size and complexity of the appeal, staff is going to defer to the staff report regarding specific analysis of the numerous issues. However, summarily, staff believes that there is substantial evidence in the record to support the hearing examiner's decision as to the issue numbers 1 through 13, 15 through 21, and 23. Oh,
Please try again.
sorry, Siri had something to say. 15 through 21 and 23 through 31. Staff believes that the hearing examiner failed to properly analyze tenant's MAR and recommends a remand hearing should be held to determine both the MAR and any potential overpayments. Therefore, staff recommends adopting resolution RSC 22-618. You, as the commission, have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that is reasonably supported, is credible, and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. And as it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you, Mr. Natalizio. Commissioners, any questions to the council? Yes, go ahead, Commissioner.
Regarding issue number 9, in reviewing the staff report, what range was used in the regulations? It just says that 14 was assessed, but it doesn't say what the top and bottom or what item from the regulations that was used.
Give me 1 second. I'm just going to have to look at the hearing examiner's decision.
All right, thank you.
Sorry, there's just a lot of scrolling, so give me a second. Okay, sorry about that. So the decision doesn't identify, but the fact that he referenced, the fact that the issue 9, the decision was for the retaining wall, the walls, gates, and fences that has the 14 minimum that he's talking about would be gates and fences. So that was what I was operating under, was gates and fences.
Got it. Just so I understand, so the wall is sort of included in the range for the gates and fences?
Unless you see something that would be more applicable that you think he was referencing, that's what I was going off of.
Okay, no, that works. Thank you.
Thank you. Commissioner Marks? Other commissioners, any questions at this time? All right. So with that, we're going to have a public comment segment now, and I know that there are people waiting with the comments that would be relevant to this appeal. Ms. Secretary?
I believe it would just be Mark. I'm not sure
Okay.
if Mark wanted to provide public comment or he was just attending to listen in.
All right. Can we ask Mark? Sir, are you here? Would you like to take 3 minutes and to speak in as a part of public comment?
Thank you for offering, but no, I'm just here to attend.
All right. Okay, then. Since we don't have public comments, I'll open oral argument in this portion of the appeal. As I said at the beginning, that the tenant filed these, both tenant and landlord filed the appeal application, but the tenant filed it first, so the tenant will go first with the argument. And with that said, I will invite to the podium Ms. Michelson. All right, so what I'm going to ask you to do is, before you begin, for the record, state your name and the city of residence, and please indicate if you wish to divide your time. You have 5 minutes total. You may divide the time to use for your presentation and later for the rebuttal, or you can take the 5 minutes at once.
Thank you. Good evening. I'm Sharon.
So how would you like to divide the time if you want to divide the time?
I'll do 5 minutes in total.
A total, okay, all right, noted. You may begin.
Thank you. My name is Sheris Michelson, and I live in the city of West Hollywood. West Hollywood used to be a city that fought against discrimination. Now it supports discrimination. And staff admitted through its opposition brief for my writ for case D4460 that it's now sympathetic towards landlords, which I've witnessed. This is bias which has been employed in this hearing and in case D4460. In case D4460 second appeal hearing, staff told you to overturn the hearing examiner's verdict, which violated federal law as it refused me my rights protected by the First Amendment. Following staff telling you how to vote, you adopted Resolution 21592. The DFEH has since ruled my condition that Resolution 21592 bans is protected by federal law and has qualified my landlord's action of violating it as discrimination. This would mean that Resolution 21592 supports discrimination, and thus you and staff have enabled and perpetuated discrimination. I attached copies of the DFEH's determination with my written statement. In this case, D4652, which raises all new issues, which staff notes in their report should be evaluated independently of other cases, staff echoes the hearing examiner who made his decisions to withhold awarding warranted rent reductions due to Resolution 21592. So this case isn't being evaluated independently, but instead with prejudice and discrimination. If I win my writ, I assume the win will reverse the resolution. I ask the Commission to evaluate the issues raised in this case without prejudice and discrimination. As mentioned in my written statement, my landlord provided no evidence such as a 24-hour posted notice or video clip proving he tried to enter my home at any time after April 29, 2021 to perform maintenance, which his own maintenance logs confirm. He never showed up on January 3, 2022 to perform maintenance in my home as he claimed. On the evening of January 2nd, a Sunday, tenants discovered that Steve Short, our property manager, was a convicted pedophile on 2 counts, which hadn't previously been disclosed to us by our landlord. Tenants complained immediately, and around 9 a.m. the next day, January 3rd, a landlord rep aggressively banged on my kitchen window and yelled, "I want to talk to you." He never mentioned maintenance. The landlord hadn't posted a notice to enter for January 3rd or let me know beforehand he was coming. To gain access to my home, the landlord comes to my door. You can't enter my unit through my kitchen window. Maintenance wasn't denied on January 3rd as it was never offered, and the letters my landlord wrote telling me I didn't respond to his request for dates to perform maintenance were dishonest, as I indeed responded to his letters promptly with time and date stamped emails. Requesting dates to perform maintenance does not equal a denial of access. My landlord also claimed on his appeal application under penalty of perjury that he mailed me a copy of his appeal application, but he never did. Not performing needed maintenance is harassment, which the city is supporting via its Resolution 21592. Echoing my landlord's operating practices, staff dishonestly reported that the hearing examiner made a determination on the validity of my unit's rent registration document when he didn't. He simply opined that time passage excused it from a determination regarding its validity, even though there's no statute of limitations for this issue, and I had provided new evidence from the ruling in D4462 proving the document is invalid. I asked the Commission to remand this issue back to the hearing examiner to determine if my rent registration document meets all city requirements for it to be valid, as this has never been determined in any hearing, such as, was it filed within 30 days of my move-in date? Does it include all amenities I've proven come with my unit? Does it include my authentic signature, etc.? Staff made several other missteps in their report, such as noting my move-in date correctly as mid-May 2011 in their opposition brief for my writ, yet noted as April 2011 in their report, and they didn't include the raised issue directional sign in their report, amongst other missteps. The hearing examiner also wasn't thorough, as he noted my evidence wasn't dated when it was, that I denied the installation of a new stove when my video evidence shows the landlord's repairman had entered my unit to inspect my red tag stove and determined it should be repaired, not replaced, that I had stated and proven all recycling bins had been removed, yet the hearing examiner claimed incorrectly I said only one was removed, that a warping bathroom wall can be qualified as small cracks, which is absurd, or that exterior wall cracks on one area of wall are the same issue as the repaired gash on a different area of the same wall, which doesn't even make sense. I didn't get a fair and unbiased hearing, and I deserve this, and I asked the Commission to award me the rent reductions the hearing examiner determined were warranted without his and staff's prejudice, uphold those he awarded, consider awarding rent reductions for issues passed over, remand the determination of my unit's rent registration documents validity, as well as other items related to my unit's MAR. Plus, I request accounting, so my landlord will have to return to me all overpaid rent and any other improperly gained monies from me, which to date equal more than $6,000. Thank you.
Thank you. All right. With that, Commissioners, are there any questions to the tenant? Nothing at this time. Ms. Michelson, you may have a seat. Thank you. And I'll invite the landlord this time to, you can take your 5 minutes, basically, and please just state your name and the city of residence. Before you begin, since the tenant didn't split, we can take the 5 minutes for the landlord, or we still can do the.
No, at this point, the landlord is just afforded the 5 minutes.
Yeah, 5 minutes. So, sir, you will have 5 minutes. Just state your name and the city of residence for the record, and you will have 5 minutes.
Good evening, commissioners, staff. Thank you so much for taking the time. My name is Adam Rosenkrantz, and I'm from Los Angeles, California. It's disappointing to have to be back before the commission addressing, many of the same issues that have been litigated over and over for a number of years now, and continue to be, problematic. And while the tenants, opening remarks were filled with conjecture and inflammatory language, that's really all they were, is conjecture and inflammatory language. She doesn't address any of the material facts, at the case or that underlie the case, and instead attempt to, readdress issues that have already been litigated, they've already been settled. And it's disappointing to see ourselves before the commission again having to deal with these types of issues. There's discussions all over about discrimination, prejudice, harassment, all of these buzzwords that are intended to incite fear into the landlord, into the commissioners, into the city staff to make a decision that's in opposite of the facts, and that's disappointing. One thing I would like to note of particular prominence is in the hearing examiner's decision, he made a determination that many of the claims that Ms. Michelson had made were not coextensive with previous litigation and current litigation that's ongoing. That statement is demonstrably false, right? In, I believe it's issue number 9, the hearing examiner noted that there have been 2 previous cases regarding the back pathway condition, D354, D4460, both of which found that there is insufficient evidence that the walkway deteriorated and that the conditions had not materially changed. Those are the same issues that are being brought up again. There was a settlement and a release of all claims that was entered into that was submitted to evidence which resolved that issue. That is a mere issue that had been brought forth back in 2019 under D4460. That's been brought over again now. That issue is barred, yet the hearing examiner continually allows for that to be considered. We still have to have a hearing over that exact issue. It's contrary to the law, it's inequitable, and it's a waste of city staff time and resources. The city continues to take the complaints made by Ms. Michelson in the same manner in which they would from any other tenant. And unfortunately, that's not what we have here. This is a tenant that lost an unlawful detainer action in a court that was found by a jury who, when she had made many of these same claims, had ruled against her, and that ultimately ruled to give possession of the premises back to the landlord, only for a judge to ultimately overrule on the basis of an equity claim. Since that time, right, there have been a perpetuation of these falsehoods, retaliatory efforts taken by the tenant to get back at the landlord for prevailing in court and forcing the tenant to pay the landlord's attorney's fees. It's been a prototypical example of retaliation and utilizing a well-intentioned process, which this is, and I value the ability for a tenant to make claims and concerns if the landlord is not performing work in a reasonable manner. Unfortunately, this process has been abused. It continues to be abused, but the city continues to allow this landlord-tenant relationship to be treated like all others. Unfortunately, it's not. We've been before this commission before. There have been voluminous rent reduction requests, city code enforcement requests from this tenant filed against the landlord. And I can only speak for the last 3 years or so since I've been involved with this building, but during that time, to my knowledge, there's been no other tenants that have made any of these claims. Ms. Michelson will say it's discrimination, it's prejudice, it's harassment, none of which have any merit, none of which are based in any fact other than pure conjecture. All of the alleged maintenance issues that are noted coincidentally have photographs attached to them that are undated. Ms. Michelson knows that the settlement agreement covers all things covering her tenancy, and undisputed is the fact that it covers anything up until the date of that settlement agreement, but coincidentally she doesn't provide any date stamp photographs that would prove beyond a reasonable doubt when these actions took place, when those photographs were taken, what the condition of the premises are. That's done to mislead, that's done to deceive, that's done to perpetuate falsehoods that maintenance is not being, has not been performed, or that the same issues have not been remedied when issues have been remedied. And it's very disheartening to see, the kind of indictment of the landlord before the city commission over and over and over. And there's so many legal things that have been going on. And this tenant, uses every avenue and every forum at her disposal to try and, undermine the landlord and to seek rent reductions and all of these, alleged deficiencies that plague her apartment unit purportedly, none of
That's
which
time.
are true and all of which could easily be
That's time.
verified if the tenant were to simply
Sir,
provide date stamped
sir,
photographs
your time is
instead
up.
of providing false and misleading information. Thank you.
Thank you, Mr. Rosecrans. Your time is up. Commissioners, are there any questions to the landlord? Commissioner Kirby, please.
Sorry, Mr. Rosencrantz, can you list for me, based upon the issues here, starting with issue 1, jumping to issue 3, can you tell me, go one by one and tell me which ones you're specifically appealing?
Yes, I mean, I think all of it's totally wrong, but, I guess the ones that
So you're appealing the decisions also where he's not, the hearing examiner's not?
The ones that I was specifically appealing, I believe, were referenced in my appeal to the Rent Stabilization Commission. I think it was I made general comments. I appealed specifically issue 5, issue 9, issue 18, issue 30, finding of fact 05, finding of fact 15, 17, 21, and 28.
Thank you.
Thank you. Other questions for the landlord? I have seen none. Thank you, sir. Thank you for your testimony. And now what we'll do is the commissioners, if there are any questions, you can address to the legal counsel before we begin our deliberation. Commissioner Wright?
I just had a question for clarity. Does the tenant still have additional time for her 5 minutes?
Well, the tenant, she indicated she did not wish to split the time between the presentation and the rebuttal. So she chose to take everything at once, because if we allow the time for the rebuttal to the tenant, then I will have to allow time for the landlord to rebut.
Well, I was just asking if she had an additional 5, because I had questions, but I wanted to wait until she did her rebuttal or additional time.
Additional time to ask the tenant questions?
Correct.
I don't think we can do that now.
Did she have any time left from her 5 minutes?
33 seconds.
33
Okay.
seconds.
I think the issue is that had the tenant divided her time, it would have provided landlord an opportunity to rebut her comments. So as you stated, if you do permit more time, you would then have to permit the landlord time as well. So
Correct.
But this is under your jurisdiction as chair to navigate how the hearing should be held.
Since I mentioned at the beginning the tenant could split the time, and the tenant, indicated she wished to take the whole time at once. So we can't really go back now and start the rebuttal. Yes.
The only thing I'll add is if Commissioner Wright just wants to ask questions, I think that's fine. But if she's seeking more testimony, again, that's up to you.
All right. Okay.
But
So then
questions, I think, is fine.
Okay. All right. So then, because I'd like to be fair to both parties, then if we will have any questions for the landlord, I will allow the commissioners to also ask the questions to the landlord. Ms. Michelson, can you come back, please? And basically, you're going to be responding only to the questions. Commissioner Wright.
Thank you, Chair, and thank you. So regarding issues 6 and 8, there's notation by staff, I believe, that the photos that you had submitted, they weren't dated. Were you asked during the hearing, like what date those photos had been taken, the ones that you submitted into evidence?
I'm sorry, I don't see 6 or 8.
I can tell you what they are. Sorry.
Is it possible to give me a page number?
Yes. So 6 was the exterior bathroom wall. 8 is the exterior bathroom wall leak, and I can give you the pages. One moment. Page 20 and the staff report. Do you have that?
Would be 6, is that correct?
I believe I have the answer for you.
Yes, please.
I included these images in a time and date stamped email that showed what the conditions were at the time of the email. I took those photos and I submitted them to the landlord explaining what the issues were, and it was as of that date.
Thank you.
Thank you.
Okay, that's all. Thank you.
Commissioners, any other questions? Ms. Michelson, please come back.
One question for Ms.
Mr. Masho has a question for you.
Good evening. The bathroom wall, it says here that it was repaired. And was it painted after it was repaired?
I believe they put paint on it, but the repair that they did was more damage. So it was not a repair, I guess, even though they had attempted to do something to the wall. The images that you have in your packet show what they did, and it's damage to the wall. So they put like putty on it, and then they put paint over it, but the wall did not look like it did when I moved in. It wasn't smooth. It had bubbles and problems. I believe there are some images that demonstrate that.
Thank you very much.
Thank you.
All right. Thank you, Ms. Michelson. So, for the record, any questions, commissioners, you have for the landlord? All right, none. Thank you. Okay, with that, we're going to close the oral argument portion, and the commissioners, you may ask questions. You may address your questions to the legal counsel this time before we begin the deliberation. Any questions? None. All right, so who would like to begin? Commissioner Martz? No?
Sure. I don't have a lot to say. I think staff did the correct job in their analysis here. I don't think there's anything that I differentiate on in terms of what they recommend. I think a lot of what Ms. Michelson has submitted is new evidence that we can't consider tonight. And I do agree with the landlord in this situation that a lot of what was stated in the filings is conjecture and suggestion without actual evidence. So I would recommend that we uphold the staff's recommendation tonight. Thank you.
Thank you. Commissioner Kerpis?
I'd like to listen to my fellow commissioners
Okay.
first, please.
Commissioner Wright?
Put on your seatbelts. Let's see, let's start with issue number 5 regarding the dishwasher. So the range for the dishwasher was 43 to
120.
Thank you. And the hearing examiner gave a much lower valuation of that to $10. And I understand that it's just a guideline, but I will say, typically in the past, we have pretty much deferred to that range. And when we were, whether it was the lowest or the highest end, we typically did defer to the range and use it as more of sort of where we were going to be rather than sort of this range that was out there that we could choose to ignore. Additionally, the regulations provides that the quality of life, the safety, health, convenience, and comfort are all considerations. And I would, I believe that, a leaking dishwasher would affect the quality of life, convenience, and comfort of a tenant. And so for number 5, I would recommend that we, at the very least, move to the minimum guideline of $43 for the dishwasher. I think that also helps incentivize the landlord to fix it, which is ultimately, I believe, what we should be striving for not for tenants to have to live with a decreased service, but for it to be repaired so they can enjoy the same quality that they had contracted for. For issues 6 and 8, which we sort of asked the tenant on just now. Sorry, I have a lot of tags on my notes. So it appears that the hearing examiner found that those specific, photos hadn't been, were undated. And according to the tenant, the emails that she sent would have been the date that those photos were taken. And I don't know if that necessarily was before the hearing examiner, but I think that at the very least with those, that they should be considered, and the condition that they were in at that moment should be, because even in the decision, the hearing examiner notices, it says that those specific, I think it was the wall, were damaged, but just couldn't assess when those photos had been taken. So there's a finding that there was damage. There's also a finding that in the prior case, there was no finding of damage. And so to me, it sort of follows that if there was no prior damage, or at least no finding, but the photos that were submitted show damage, that there should have at least been an assessment of what the value of that damage was, rather than it just being sort of discounted and we don't know the date, so we can't assess whether it was the current condition at that time.
Sorry, Commissioner, which item were you on for that one?
That was issues 6 and 8. And then there are sort of quite a few where the hearing examiner sort of says that it's the tenant's fault that those specific items weren't repaired. And so, based on that, doesn't make a decision or really a finding for the tenant. And the one that I'm sort of looking at right now is issue number 10. I'll give the page number so it's easier to... The sink stopper. The evidence that is sort of pointed to is the tenant refusing to allow entry. It's exhibits number 21, which is page 187, and exhibit number 22, page 188. So the email from the tenant that mentions the bathroom sink not working is dated March of 2021. And then the response from the landlord is dated January 4th, 2022, which is almost a year later. But this letter doesn't say what issues they were trying to repair. It just says, we were here to repair these issues. And so without knowing that they were there specifically to replace or to fix the stopper, I don't know that we have evidence that she refused to allow them to fix the sink if it doesn't say in the letter that that's what they were there to do, and this was almost a year later. And I think that happens quite a few times throughout. For issue number 11, it's the same thing, and a few other issues where they're using this letter that was, given by the landlord quite some time after the complaint, and it's very general. And so I don't know that that sort of meets the standard of, substantial evidence that, she refused to allow them into her apartment to fix that specific issue. And so she's done, I believe, her part of submitting evidence that she asked for these things to be done, but that we don't have evidence from the landlord that shows that they attempted to repair that issue. And so it's a very robust case and a lot of issues, and it appears that staff is already sort of recommending that we remand it for the MAR assessment. And so I would also, and I can give the numbers if someone else talks and you come back to me, of the other issues that I think should be remanded and the reasons why, just so we do have a full record of sort of, the tenant saying this, she asked for this to be done, the landlord said, oh, well, you wouldn't let me in for that issue, and we just are able to match those up. But those are my comments. Thank you.
Okay, thank you. Commissioner Maggio?
So the commission must determine the following. Is there substantial evidence supporting the hearing examiner's determination regarding issues 1 through 13, 15 to 21, 23 to 31, which we are discussing now? And also the second, of course, is there substantial evidence supporting the hearing examiner's determination on the maximal allowable rent and overpayment, which shows, of course, that The landlord thinks the rent is $1,255.09. The tenant has been paying $1,232.09, but the rent really looks like it should be $1,220.09. In regard to the issues that were granted a rent decrease, the dishwasher, back pathway walk and molding, graffiti, staircase, garage wall, and the back pathway drainage, I am in agreement with, and with the additional award of $10 rent reduction for unit-specific issues and 57 for common area issues, which is a total of $67. I did have concerns over the two issues of also of the dishwasher. If indeed there is water leaking from there, I think that is something we have to look at more closely. And the exterior bathroom wall leak, water leaks are unfortunately very damaging, and there seems to be quite a bit of water damage in this building, which shows very specifically in the garage area. Those are my comments right now, Chair.
Okay, thank you. Would you like Commissioner Corpus?
So I'm in agreement thus far from what I've heard that the staff did do a thorough job in completing this report, and agree with them in their analysis of upholding the hearing examiner's decisions. In response to item 5 and the range, because the hearing examiner did not specify very clearly in the decision, I can understand where fellow commissioner might have questions about the range or the dollar amount chosen. I think to resolve that issue, we would have to ask more questions, such as how much water was leaking out, and a variety of other questions that I don't think is appropriate for us to be asking at this time. And I wouldn't object to remanding that issue back to the hearing examiner for the hearing examiner to provide an analysis of the amount that they choose, whether it be $10 or more. In regards to issue number...
I'm sorry, you're talking about the dishwasher now.
I'm talking about the dishwasher. Yeah, issue number 5. Mm-hmm. Now I'm talking about issue number 10, that I actually disagree. I mean, this property and this tenant and landlord and these issues have had a long history with the city and the commission. The commission in the past has passed resolutions specifically addressing certain issues, and has solidified and agreed that the tenant oftentimes has not provided access to the property. And I think that this, based upon the January 4th and the letter and the February 22nd letter, is a continuation of that pattern. I wouldn't expect, out of all these issues that are listed, I wouldn't expect that a huge deal would be made by the tenant or the landlord specifically on the issue of a bathroom sink stopper, to use that as the reason for remanding this, because I wouldn't expect them to write a specific letter specific to this issue out of all these issues that are listed. So I'm comfortable with the hearing examiner's analysis of the situation, of the access issues, again, based upon what this commission has already done in the past and what is in front of us now.
Thank you. Vice Chair? Vice Chair, if you're ready. Yeah.
I do agree with Zakia on the point of perhaps we can value the cost of the dishwasher at a higher rate, and the $43 that Zakia suggested seems reasonable to me, because to have to clean up after a leaky dishwasher every time you use it, and applying a value of $10 a month to that, it seems like it should be more, and it should seem like there should be some incentive for the landlord to make that correction, which, again, I agree with Zakia that should be the point of this whole, process, is to get that situation resolved. I was noticing that in the resolution under, let's see, Section 4, Part I, which starts with the bathroom sink stopper issue, but later in the paragraph it does say in the staff report that the hearing examiner noted that the record also demonstrated that tenant had resisted landlord's efforts to attempt repairs, and therefore no rent decrease was warranted. Landlord has documented that it attempted to schedule dates and times for inspections regarding the tenant's numerous maintenance requests and has been met with silence or refusals. So I do believe that the landlord has made a reasonable attempt to try to fix a lot of these issues. And I don't think I would remand that part back. The issue of remanding the MAR, I do believe that we should do that. Yeah, and those are my thoughts. Thank you.
Thank you. I'm going to be brief because I agree with most of my fellow commissioners' comments made, supporting the findings of the examiner, and I believe that the examiner's findings are supported by the record evidence. So I did point out when I was, I was reading this appeal, the items 6 and 8 that Commissioner Wright pulled, and those items, I believe the tenant did not meet her burden. The photographs, they're undated, and if they're undated photographs, you can't really, I understand the issue could have been there, but if the photographs are undated, you cannot really say when these photographs were taken. When the photographs were taken. So that's why I don't believe that the examiner erred in this, regarding these issues, 6 and 8. So, but I read it over and over again at home when I was preparing. And the other item I also paid attention to is the same, the issue that Commissioner Wright brought up, number 5, that Vice Chair mentioned also, and others, I believe, regarding the valuation of $10. So I see the way of thinking. The examiner came up with this lower $10. I'm not saying that I'm in favor of it, and I believe that could have been higher amount, but the examiner justified, provided the reasoning why it is $10 of reduction, and that was the examiner's decision based on the explanation or justification, which says the dishwasher is operating. So basically, the tenant can use the dishwasher, and there is a leak that has minimal effect on tenant's health, safety, quality of life, or the unit's habitability. That was the examiner's justification for the lower amount of the rent reduction. So, and I'm, typically in favor, and I agree with the Vice Chair, because we've been both on that task force, right? And revisiting the guidelines, the evaluations. to bring them up to kind of higher amounts. And I would, again, I'm not going to be against the giving more reduction, but I don't believe we should remand this to the examiner. The commissioner has the power to decide the amount tonight, right now. And if there is no support for the establishing $43, so then I'm fine with $10, but I don't believe we should remand this back to the examiner. As to the as for the MAR determination, I absolutely agree with staff. This has to go back because there is no reduction of housing services determination with an incorrect MAR. So definitely has to MAR has to be determined and see if there are overpayments there. So with that said, I would agree on with the to affirm the in part and remand in part the hearing examiner's decision. But if anyone wants to, wants to bring a motion for these $43 for the dishwasher, I'm fine with that.
I have a few more comments just to see if I can convince my fellow commissioners to to remand a few more issues, or at least to reconsider. So looking back at issues 6 and 8 that we had referred to, on page 116, where the hearing examiner is discussing, whether those issues, this was essentially about the dates and whether those photos, were, what dates they would have been submitted, et cetera. On page 116, it talks about that this issue had previously been submitted in 2019, and the evidence then showed that there was no new evidence of a leak that would require overturning that decision. I'm sorry, before that it says in January, the tenants at that time couldn't prove the existence of the leak. And that's the first paragraph on the top of page 116. The second paragraph, the current hearing examiner says that the repaired portion of the wall is indeed in unsatisfactory condition, and refers you to page 40, to exhibit 44, which is on page, starts on page 261, and it has several photos of that. And so there's no question on whether the current condition of the wall is in need of repair, because it says it's indeed in unsatisfactory condition. But the hearing examiner is unsure if those photos predate 2019, which appears contradictory to the prior paragraph where the examiner says the tenants did not prove that there was any damage. And then so looking at the exhibit, starting on page 261, the tenant sent those in June of 2021. I think there's no reason for us to doubt that those photos, when she sent them in, were recent and taken around the time that she sent them, asking for them to be repaired. And so to say that she didn't prove her duty when she submitted exactly what she emailed to the landlord, I think it's putting this maybe an unreasonable burden on the tenant to double prove something, right? She sent it the day that it happened. Well, and so I just think that, if we can't sort of overturn, and make the decision tonight, that at the very least we should send it back to the hearing examiner. I mean, they can ask for metadata. There's other ways to establish it, but I don't know that we have any evidence to disbelieve the tenant, and it seems that we're starting from a place of disbelief rather than accepting the evidence as submitted and asking the landlord to rebut it. We're doing it backwards. So that's sort of my issue on 6 and 8. I don't know if there's an appetite for the commission for the other issues, so I'll leave that there, but at the very least, I would want us to increase it to 43. I don't know that issue needs to be remanded because it is the guidelines for issue number 5. And again, I think there are additional issues with the evidence on 10, 11, et cetera, if we want to revisit those.
Okay, since the commissioners already spoke, I don't know if the commissioners have additional? Okay.
Question, so what is the basis for moving it to 43?
Excuse me?
What is the basis for valuing it at $43?
Oh, it's the minimum of 43, and the regulations provide that if it affects the quality of life, safety, health, convenience, and comfort, it checks 3 of those boxes. I would imagine the quality of life, convenience, and comfort to have a leaking dishwasher.
So if we had a dishwasher that had a huge gash across the door, that was, maybe even sharp edges because of this gash, would we value it that the same way?
Well, we could go up to 120, so I don't know that it would have to be the minimum. This 43 is the minimum.
That's what I'm just trying to understand where we're getting 43 when it's just guidelines. So if there was a gash and it worked 100% properly, but it had this gash in it that could potentially cut somebody as they walk by, and it doesn't look nice, I think that has a value as well. But to compare the two, the scenario I gave and the scenario we have in front of us, to really say which one's worse, wouldn't we have to know more about what the current situation is, and to determine like whether it's a small leak, a large leak, if it takes 5 minutes to clean up, 2 minutes to clean up? I mean, I wouldn't want a dishwasher that leaks at all either. Yeah. But in terms of valuing it, the value isn't to incentivize the landlord to fix it. The value is supposed to be the value that the service provides. And so I'm just trying to figure out how we justify $43 or $45.
Sure, I'm happy to answer that. So the scenario that you gave, it's not before us, and so I think it's sort of, trying to grasp at these other scenarios that are potential. I think we've, typically gone with what the guideline was, the minimum, the maximum, and anything in between. This is so far below the minimum that we don't have any evidence as to why. But if we read, are reading the regulations where it describes what we're to consider the quality of life that this has on the tenant, the safety to the tenant, the health to the tenant, the convenience, and the comfort. And so for me, if you know that you don't want a dishwasher that links, and I think we can also assume that the tenant doesn't either, and so that enough of those quality of life, convenience, comfort, the things that we're supposed to consider appear to be sort of implicated by this issue. And so I think the minimum is probably the worst that we could do. And below that just seems like we're going to start having rulings that are sort of everywhere if we're not at the very minimum following our own guidelines.
And that is completely fine, Commissioner Wright, the way that you're explaining. So the commission has that authority, right? So that we don't have to really put that justification. So we find if the commission believes that the amount given is lower than the commission finds, whatever the amount would be more appropriate. So we don't really have to find these justification for that. I see that the same thing, that the same factors that you're using to justify the higher amount, the same factors used by the examiner to give a lower amount. So it's going to be very subjective. But the commissioners, or if the majority of the commissioners agree to give a $43, because $43 were suggested by Commissioner Wright, so we don't really go there into that discussion why it's 43 and why it's not 50. So that was recommended by Commissioner Wright to use that $43. If I see that a couple of commissioners are in support of that amount, so we can ask if other commissioners may have a different amount in mind or different figure in mind. But if we have this $43 figure, so we can put that on a motion and vote on this and see if it's going to pass. If not, so then it will be $10. I think we don't really need to go into that, open the discussion on why it is 43 and how the commission will arrive to 43 and not to some other amount. So I definitely don't want to go there.
Chair, if I could respond briefly. I'm in support of the $10 still, and I appreciate Commissioner Wright's explanations. I think, we go back to the very basics of, is there substantial evidence in the record for what the hearing examiner decided? I think there is. On page 108 and 109 of our packets, it clearly explains why the hearing examiner went below the guidelines, which again are just guidelines, and it's pretty rare for us to see a deviation by this amount, so I'm led to believe there's a reason for that. And then, going to page 108, they explain themselves, and to me it satisfies all of our regulations and the municipal code of what we need to uphold this, is that because a dishwasher is operating and the gasket is largely intact and has minimal effect on Ms. Michelson's health, safety, convenience, and, or quality of life, and no effect on the unit's habitability, $10 is assigned. And I think that's more than a reasonable explanation for myself and for what is required under our RSO.
Okay. So since the commissioners already spoken, they, stated their kind of, agreement or disagreement on the on these items. I don't think we have to go another round of discussing the issues. What I will suggest at this time is that if we want to come up with the motion, and if it's going to be different from what is recommended by the staff, we'll go from there. But legal counsel?
If I could just recommend a procedure here, if the commission could just do a informal straw poll regarding the valuation, because if ultimately the commission decides it wants the $43, I'm just going to need to then just amend the resolution, and then I'll have to read those changes into the record. So if we could do before a formal motion just a straw poll to see if it's going to be 10 or 43,
okay,
that'd be helpful. Thank you.
All right. So let's just see if the commission would support that that the valuation, the amount would change from $10 to $43.
Now, one question before we go in that direction. Although I feel 43 is a little high, and I feel 10 is too low, and I would suggest more like 25, because I think it does leak, and I think that would be a better compromise.
But again, so the whole argument was that we use the, because 25 is going to be still below the guidelines, the commission rights firm state basically position is that it has to be at least the lower end of that guideline. So I don't want to really go into the whether it's 10, 25, or 20 or 4. So let's do the 43 as Commissioner Wright. Commissioner Wright's argument is supported basically why she believes it has to be 43, and Vice Chair also agrees on that amount, right? As I understand. So let's just hear from the commissioners. Do we need to vote on this, or I can just ask? Yeah, Commissioner Wright, 43 or 10?
43.
Okay, Commissioner Maggio.
Neither.
Okay, Vice Chair?
43.
43. Commissioner Martz?
10.
Okay.
So I'm
Commissioner
neither, because I think we're changing the commission's policy by just accepting the fact that we take the minimum guidelines. If we want to do that as a commission, that's fine, but we need to apply that in all cases. We're talking about a change in policy. If you just take Commissioner Zakaya's or Commissioner Wright's argument, then we should apply that same argument across the board. And we need to discuss that as a commission if we want to do that.
Well, we're not taking the minimum. We're taking 43.
But for no reason.
Well, the reason...
Other than that's the minimum guidelines.
Well, because it is in the guidelines. It shows $43, and the Commissioner Wright finds 43 is the, is the right figure to use. She could have said 45. I mean, they could have said 45 or a different amount. So they believe it's 43, and that's the amount I'm suggesting. So we can't vote on every dollar amount that everybody says. So let's go with this 10 or 43 and see if we get support. If not, so we'll think what we're going to do next. So are you for?
You're still asking us, you're using two different arguments and combining them together. If we're not doing 10 or 43, then we're going with the minimum. Or if we're not choosing 45, as you just gave an example of, then we're not following.
So what are you suggesting?
I'm just saying that we should know what we're doing if we're just going to move it to 43 because that's the minimum of the guidelines.
It's not about the minimum. Well, that's all right. Commissioner Wright, would you like to, at this point, clarify why it's 43 and whether it has to be a minimum or it's just 43, or how can you clarify that? So then we answered Commissioner Kerpus's question.
Sure, and I think it is, for me, it's looking at sort of what we've done in the past. We have typically stayed in between what the guideline range is. And so to depart from that without, and I don't find that the hearing examiner necessarily gives a reason that I can sort of understand as to why it's so far below. And so I think at the very least to stay within the guideline, and also because it affects multiple areas that we're supposed to consider of how it affects the tenant. And again, the quality of life, convenience, and comfort. I think because those areas of her life are affected, and even if we say it's a de minimis amount, then I think de minimis would still put us at the minimum amount of the guidelines.
And I agree with that clarification, and there's nothing else I want to add. And there's nothing wrong to use the figures that are within the guidelines. And it happens that the $43 is within the guidelines. So I'm fine with the 43, and I still want to ask you: you're supporting that, or you stick with the examiners?
The what?
Recommendation.
$10. Okay. So, and I'm supporter of 43. We have 3 people for 43. 2 commissioners kind of abstain or neutral. No, 210 and 1, and Commissioner Maggio doesn't have any position on this.
My position,
or your position is just neutral.
my position is that 10 is too low and 43 is too high.
Okay, so then we have 2 commissioners, 10. What happens in that case?
Well, it sounds like at this point, then a motion's going to have to be made, and if the motion can't get the majority, the motion fails. So a motion would have to be made for, again, assuming nothing else is being changed, the motion would be to adopt resolution number 22-618 with the change of the valuation from $10 to 43.
43.
And so if
Would we use amended or to be amended? No.
right, and so if that motion fails, meaning you don't get 4 votes, then you would have to come up with another motion.
Okay.
So, but before we get there, there were sort of other issues that I wanted to discuss, and I don't want it to sort of get confused. Are we able to take sort of that portion of whether we want, to go to 43 or not as one motion, and then I can talk about the other issues to see if we want to discuss those before we pass the entire, whether it's going to be amended or not, before we pass the entire resolution?
I mean, legally, you could do that. It's up to the commission how you want to do this, but that's an option for sure.
I'm personally not in support of that. I'd rather go through everything and do one omnibus resolution to get everything out of the way.
Yeah. I agree with that.
I think just procedurally, it's too much work to do multiple motions.
Yeah, I agree with that. So let's just, other commissioners, Vice Chair and Commissioner Maggio, would you agree to that we're going to have one motion with a change of the amount from 10 to 43 and see if it will pass?
Yes, I would agree to that.
Okay. Any commissioners, anyone would like to make a motion? Yes, legal counsel.
Well, let me just clarify. So it sounds like, though, Commissioner Wright has other matters that they would like to address in terms of amending ultimately what's adopted in the resolution, not just the 43. So if there are other things that
To amend,
then I think what Commissioner Martz is saying is we should go through. The problem is we're going to have to go through each one and determine what the commission is going to favor or not, and then depending on that, that will ultimately change what I need to amend in the resolution.
or why don't we just hear from Commissioner Wright, see what are the other concerns that Commissioner Wright has, right? And then we can, and then the commissioners will decide whether they would agree to remand those issues to the examiner, or we're just going to say, you know, we'll vote as is. All right? Yeah, just go ahead. This is your time, Commissioner Wright.
Awesome. So the other issue, what I'd said before about 6 and 8, and I gave the page numbers that I'll have to refind now.
Will these be the photographic exhibits that you're bringing to our attention?
Yes.
6 is on 115, I believe.
Gotcha. And then, so the exhibits are on 261, where it talks about, you know, what they're unable to identify what the pages were, and then where the decision is discussed.
Isn't that 115?
Oh, 115? Okay.
I think that's what you're referring to, the decision, the hearing.
Yes, thank you so much. I believe that's, yes. And so I don't know if I need to remake the argument, but it was essentially 6 and 8, that it appeared that we had evidence submitted by the tenant that the damage was current, and that should be remanded to the hearing officer. The other, do we want to take that one before we move on to the next one? That way we're not flipping a lot of pages.
Yeah, I would recommend we do a little straw poll on each of these, and cool. 6 and 8, Commissioner Wright saying remand is your recommendation on these to gather further evidence?
Yes.
Okay. Go ahead, Chair.
Okay. 6 and 8, commissioners, let's start with you, Commissioner Martz. Remand?
I would not be in favor of that. I
Okay.
think it's
Commissioner Krupis?
I'm not sure yet. I'm still reviewing what was just mentioned.
Okay, I'm not in favor of remanding, Vice Chair.
I'm not in favor of remanding only because it seems that the landlord demonstrated that the tenant did not respond to requests to schedule work.
Thank you. Commissioner Maggio?
I'm in agreement with Karen, and the only thing that I want to change is the valuation of the dishwasher. That's all I want to do. I feel it's too low. There should be no leaks. No leaks. That's the way it is. I mean, a little leak becomes a big leak. Water is heavy.
We'll go back to that before we put the motion on. But on this item, issues 6 and 8, 4 commissioners do not believe this should be remanded, so we don't have a support. So the next, what are the next issues, Commissioner Wright?
The other issues were 10 and 11.
The stopper?
Yeah, the stopper with me.
And the caulking.
Correct, yes. That I wasn't satisfied with the proof that the landlords had attempted to enter the unit to fix those specific issues. I don't think it's sufficient to say at some point a year later they attempted to enter the tenant's apartment to fix something, and she refused because there are so many issues here that I don't know what that was, and so my recommendation would be to remand it, and there be sort of an apples to apples of, she asked for the stopper, this was when they came to fix it, they didn't, fine, she asked for something else, the caulking, they came to fix it, instead of it being this sort of overall that they came on 3 different dates and she would never let them in to fix it, I just don't think that sort of bears out in a sufficient proof that she said, no, you can't fix these specific things.
Okay. All right, so then that's number 10, right? We're talking about the bathroom.
8 and 10, or excuse me.
10, 11.
10, 11. 10, 11. All right. Commissioner Martz on these two?
I'm not in support of this. I think there is substantial evidence that the landlord attempted, the tenant refused, and I think Commissioner Kirby's explanation in the beginning of deliberations was correct.
Okay, thank you. Commissioner Kirby?
Yeah, I would say on 10 and 11, I'm strongly opposed to altering the decision. But to go back just a little bit,
Okay.
not to the $43, but back to the issue 6 and 8. I do understand the argument there, and I think I do agree with Commissioner Wright on that the hearing examiner did not erred in that, because he did conclude that it was not fixed correctly, and he just kind of threw out as a question, well, it wasn't established. I mean, the tenant testified that this is what it is as of today, and they could have looked at the email, the date of the email.
So for that item, as I said, so the four commissioners voted against remanding. So there are only 2 in favor. So on number 10 and 11, how would you, what would be your, you said already no, right? Okay, so for those 2 items, I also, I'm going to say no to remand. Vice Chair? Vice Chair?
Oh,
Yeah.
no on the remand.
No on the remand. Okay, so we already have 4 but I'm going to ask Commissioner Maggio, of course.
Commissioner Maggio needs to weigh in.
Commissioner Maggio, I'm going to ask for Commissioner Maggio. I said yeah.
Well, although let's see, it's a stopper and the caulking,
Yeah, that's number 10, 11.
If a stopper is important, caulking is important, but if these work people were not allowed entry, I mean, how can anything be rectified? It's just, so I'm going to have to leave it as it is.
All right, so that would be against remand. Okay, we're not remanding number 10 and 11. Commissioner Wright, other items?
No other items, thank you.
No other items, okay. All right, thank you. With that, so I don't want to really start the discussion about the dollar amount for that's becoming comical. So let's just have 43 as a reasonable amount for the reduction of the dishwasher versus the $10 that the examiner came up with. And anyone wants to make a motion?
Chair, I would offer a compromise, not to complicate things, but I think there's not quite support for either 10 or 43. I would make a motion that we adopt the resolution, but with a remand on the dishwasher amount to allow the hearing examiner to clarify and further explain an appropriate amount, whether it be 10, 43, 120, 180. I don't want to be stepping into those shoes. I think 10 was perfectly fine, but I can understand why people might think that 43 is the better amount. But I think if we're remanding on the MAR, it's another, half hour of their time to do the dishwasher as well.
Second.
So
I can make that clear.
that's why we have lawyers here,
Yes.
obviously.
So
but
I will
you
make a
could
motion
come up
to
with that.
adopt resolution RSC number 22618 with an amendment on item 5 to also remand on the dishwasher.
Second.
All right, we have a motion.
I'm sorry, Chair, just to be clear, that motion was remanding purely for evaluation,
On
correct?
the dishwasher, yes.
On the dishwasher.
And of course the MAR, which is already included.
Correct.
Right, so the only change is the remand for the valuation, the determination of the amount. We have a motion and a second, and as further discussion on motion?
Yeah, I just have a question. Based on that motion, are the parties able to submit additional evidence to justify whatever the new valuation may be?
If the commission orders it.
Okay, I think if we amend the motion to allow the parties to submit new, different, additional, or clarifying evidence, then I'd be in support of that motion.
On the dishwasher.
On the dishwasher issue, right? So, and I support that that amendment. So, go ahead, Mr. Natalees.
I was just going to say that there's either two ways: either that can just be a friendly amendment and Commissioner March can accept it, or if there wants to be a actual discussion and motion because they're not in favor of it, then they would need a second. So it kind of depends on the commission.
I would accept that friendly amendment. Yeah.
All right, Commissioner Maggio, would you still second that motion with that amendment? All right, so
Yes.
then
I continue to second the motion.
that's perfect. So, other commissioners would like to make any comments at this time?
So I'm just going to throw this out there to attempt to amend the motion just to include the items 6 and 8 to remand those.
You want to remand 6 and 8 now?
But we
No,
already
6
spoke
and 8
about
was
it.
the.
And I would not accept that from the motion.
Yeah, we
I'm
already.
still friendly with
we
you,
already
just
have
not
a
on your motion.
We have a motion on the floor. We've had further discussion. We need a
That's what I was
vote.
amending.
I call for the vote.
Wait, hold on.
We're
hold
still
on.
working on the amendment.
No, but that 6 and 8, we already spoke about it, and we're not remanding.
Well, I would
these
second
items.
that motion.
So-
If he doesn't accept the
Mr.
amendment, I
Nalizio,
second
could you
it.
discuss the process for that?
Yes, okay, so,
Accept the vote.
so at this point, if a friendly amendment isn't accepted, then even though there was an informal straw poll, this is all now formalities. So if Commissioner Kerpes makes an amendment, a motion to amend the motion to include a remand for issues 6 and 8, as long as that gets a second, it has to be voted on. So what will happen is then a vote will happen on purely just whether or not items 6 and 8 are going to be in the remand. If that motion fails, it will then go to the motion with the friendly amendment, and then that will be voted on. So because there was a motion and Commissioner Wright is saying a second, the commission now has to actually act and vote on Commissioner Kerpes' motion.
So Commissioner Kerpes' motion is to include the issues number 6 and 8 for remand, but it's not just voting on that only, but it's part of the entire motion, just to include 6 and 8 as a remand.
So just to be clear, this vote the commission is about to do is whether or not items 6 and 8 are going to be remanded to the hearing examiner for.
Well, part of the motion.
Right.
Whether it be part of the motion.
Right, it'll be,
too.
right, exactly.
So we would have to then vote on the entire motion regardless.
Right, so this is just this was to vote on whether or not to include this in the underlying motion.
All right.
Thank you, Commissioner Kerpes.
Thank you. And you're making that motion? Or,
Did.
you
And
already
it's
did, and you seconded? All
Yeah.
right, so I missed that part. I didn't hear if you made the motion. All right, Commissioner Maggio made the motion, and I'm sorry, Commissioner Kerpes made the motion, and Commissioner Wright seconded. And Ms. Secretary, we have maybe we have a roll call vote.
Commissioner Kerpes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
No.
Commissioner Wright,
Aye.
Vice Chair Ayers,
No.
Chair Topshin.
No. What do we have?
So a 3-3 fails.
3-3 fails. All right. So then we're going to move to the motion made by Commissioner Martz and seconded by Commissioner Maggio, and that is basically the change will be to the valuation to use a different amount to remand it to the examiner, and also open the record for additional documents, evidence from a tenant and a landlord. So that is the motion and the second. Now, Ms. Secretary, we're ready for the roll call vote.
Commissioner Kerpes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Wright,
Aye.
Vice Chair Ayers,
Aye.
Chair Topshin.
Aye. Motion carries. Thank you. Thank you, commissioners. Thank you, staff. And I want to thank the parties also, tenant and the landlord, for being here. What I'm going to say is basically, if you have any questions, tenant and the landlord, the parties, if you have any questions, you can approach staff after the meeting, and they will be happy to answer your questions, or you can contact them during normal work business hours at the department's phone number, which is, Ms. Secretary, can you state the number again?
Give me
I
one
always forget.
second.
Yeah, I think it's, sorry for putting you on the spotlight like that.
It's okay. I have it now.
Okay.
It is 323-848-6450.
Okay, 6450. Thank you. All right, so that concludes the appeal portion of our agenda for tonight. And the next item would have been new business, but there's nothing scheduled under new business, so we don't have anything under that item. Items from staff.
Just to let the commission know, the case has been sent to you, so you should have that in your inboxes now.
Thank you. All right, public comments. Ms. Secretary, anyone at this time
No
wants to
public
speak
comment.
here? No, all right, good. It's too late for that. Commissioners, any items from you? Nothing? Commissioner Martz?
Sure, I have one. It's been a while since we've been here, but the governor signed in 38 to 40, depending how you count, housing bills. So there are so many wonderful changes. Not many of them are rent stabilization related, but housing, tenants, mobile homes, lions and tigers and bears, oh my. So we're seeing a lot of changes coming, whether they're good or bad, it's up to your interpretation, but for me, it's very cool and exciting.
Thank you, Commissioner. Other commissioners? Commissioner Wright.
In-person voting begins on October the 29th. Fiesta Hall will be open 10 a.m. to 7 p.m. for in-person voting. So you can vote in person if you don't want to mail it back on Saturday.
Yeah, thank you. And I would just say, get out and vote. That's, everybody should think about it. I already voted and an absentee ballot, but so November 8th is coming up, so everybody should vote. Now, since we don't have anything else on our agenda, I'm going to adjourn this meeting of the Rent Stabilization Commission until the next meeting, which is going to be on November 10th, 2022 at 7 p.m. here in West Hollywood Park, Public Meeting Rooms, Council Chambers. Thank you, everyone, and good night.
Karen, you know what? When I mailed my ballot in, I put my address, I signed it, but I didn't put...
Sir Nicholas Catelli from the Royal Classics Thespian Review. Now, in this segment of Free Theatre in the Parks, we have the rarest of rare opportunity to experience the hilarious romantic fantasy classic, The Romantics, by the late 19th century French poet and playwright Edmond Rostand. Now, of course, Edmond Rostand is best known for his later classic Cyrano.